There's no reason not to do it. Okay, excellent. Well, good afternoon, everyone, and welcome to today's book panel on Renée Lettow Lerner's book, The Jury, A Very Short Introduction. There are copies there for all of your enjoyment for purchase, but it's a very small, very full and excellent book, and therefore it is a great bargain. So I highly recommend that you move to that table. But in any case, I'm Professor Francesca Bignami, and it is my great pleasure to be moderating this panel. The book is a true gem, as I just alluded to. It's a gem to hold, it's a gem to look at, because there are tons of very appropriate, excellent illustrations in here. And most importantly, it's a gem to read. It is full of pithy explanations, wonderful insights, and entertaining stories. Very entertaining stories. So it's really a fun read as well as everything else. But my role right now is simply to introduce our speakers, and we have 3 of them. They will each be speaking for around 10 minutes, and then the author will have time to respond to the comments, and then it will be your turn for questions and answers. And we're very much looking forward to this being an interactive session with the entire audience. Our first speaker and the author of the book is Professor Lerner, and she hardly needs an introduction. She is the Donald Philip Rothschild Research Professor of Law here at GW Law. She's internationally recognized scholar in the areas of legal history, criminal and civil procedure, and comparative law. She is a prolific author, and she is on the leading American case book on the civil law tradition. So she's one of the foremost experts working in the United States on the civil law tradition writ large, meaning the United States, but also the UK and other jurisdictions. Second and third, with us on Zoom to discuss the book are 2 of the country's foremost scholars of comparative criminal procedure and juries, Professor Máximo Langer and Professor Anna Offit. Professor Máximo Langer is the David G. Price and Dallas P. Price Professor of Law at the UCLA School of Law. He has published widely in the areas of comparative international criminal law and procedure, with a special focus on plea bargaining, juvenile justice, and prosecutors. He is the faculty director of the UCLA Promise Institute of Human Rights and director of the Transnational Program on Criminal Justice. He is also president of the American Society of Comparative Law. Anna Offit is a professor at Southern Methodist University Dedham School of Law. She is both a legal scholar and a cultural anthropologist, and she has written extensively on juries and jury reform. Her recent book was published by NYU Press in 2022, and it's entitled The Imagined Juror: How Hypothetical Juries Influence Federal Prosecutors. And so now, there's no more for me to introduce. I now give you the floor to the author and our first speaker, Professor Lerner.
Thank you, Francesca, for that very kind introduction. It's wonderful to see you all here. Thank you for coming. It's hard to explain how much it means to an author that somebody might be interested in the book and might actually get and read it. So thank you. Thanks to Rosa Solorio, GW's Associate Dean for International and Comparative Legal Studies. And she was working with me to develop this event. And Rosa is a fountain of wisdom and energy. Thank you. And to Leah Calabro, our International and Comparative Law Fellow, for organizing the event. Leah always makes sure things run smoothly, and this is no exception. I'm delighted to welcome Anna and Maximo. It's very kind of them both to make time to be with us here today, virtually. I've relied on their work in writing this book. Anna's on comparative juries and Maximo's especially on abbreviated procedures or comparative forms of plea bargaining. and I'm looking forward to hearing what they have to say. Well, writing and publishing a book takes more than one person, and I have to give credit to my husband, Craig. In preparing the manuscript, he was invaluable. By the time it came to submit the manuscript, it was twice as long as it should be. Oxford has very strict limitations on these very short introductions, and I was well over. Fortunately, my husband took a pen and just slashed through paragraph after paragraph to give you the concise volume you have today. This book took 18 months regarded in one way. But in another way, it's the culmination of decades of research on the jury. And I realized it's been 30 years since I started researching and writing about the jury. Ever since I was a summer associate at a law firm here in town in the summer of 1994, and I was working on a case that I will never forget, Jackson versus General Motors, involving a civil jury verdict in Mississippi. And that set me off down a path that I follow to this day. That case got me interested in the Anglo-American jury. But a different case got me interested in comparative juries. And that happened in the spring of 1999. I was sitting at my desk one day here at GW, and I got a call. It turned out to be a lawyer from Paris. And this guy said, "Do you speak French?" I said, "Mais oui." He said, "Do you know anything about American criminal procedure?" And I said, "Well, I profess to." Then he explained that he had a client who was charged with committing a double murder in San Diego. At this point, I was baffled. You know, why is he calling me? And why is he representing this client? So it turned out that his client was a dual French-US citizen and who had fled after these events to France, was arrested in France. And it turns out our extradition treaty with France allows France to try its own nationals in its courts and not to extradite to the US, even if the crime was allegedly committed in the US. So he said, "Can you come to Paris to explain to the court American criminal procedure for the defense? And that event will be in June, the hearings will be in June, and it will be paid for by the French government." And I thought long and hard about that one. And I said, "Oui." So with that, I got to know the mixed panel, which I had not been familiar with before. The mixed panel in the Cour d'Assises in France. And I'll never forget the first time I walked into that courtroom. It's a very grand, the Palais de Justice in Paris was very grand before they replaced it with a new modern, glass building. But it was a magnificent courtroom with a very high and wide bench. There were 3 judges sitting in the middle of the bench in robes. The presiding judge in red robes with ermine trim, which he called mes animaux, my animals. On either side of him were 2 other professional judges in black robes, and on either side of them were arranged 9 lay jurors. It was remarkable to watch that proceeding. The jurors could ask questions directly of the defendant and witnesses without having to go through the judge. Because there were essentially no rules of evidence, there were no lengthy sidebars or sending the jury out of the room while they were discussing how to deal with some particular evidentiary rule. So that was a remarkable introduction to different forms that lay jurors can take in different places. I have to say, one of the marvelous things about working on the jury is that nearly everyone has some experience, either direct or indirect, with a jury. And there are endless shows and movies about juries. So most recently, some of you may be familiar with Jury Duty, involving the maybe unsuspecting, it's a little hard to tell, juror Ronald Gladden. And in the spring of 2022, a real-life jury, not too far from here, in Fairfax, Virginia, was deciding the case of Depp versus Heard. I'm fortunate to know through my brother, one of Mr. Depp's counsel, Benjamin Chu. And he's read the book, and I've talked with him about the book. And right now, of course, in New York is going on the trial of Sam Bankman-Fried, another case I'm very interested in. So I've benefited over the years enormously from the work of academics and lawyers and judges about the jury, but I've also benefited from hearing from jurors themselves about their experiences. And their views deeply inform this book. This book covers all types of juries. It covers grand juries, criminal juries, and civil juries. And it looks at the history of them and how they've developed around the world. The jury is not just an Anglo-American phenomenon. Sometimes we think of it that way. But now it's found on 6 continents. In 2008, South Korea adopted a form of the jury. In 2009, Japan did. And several provinces in Argentina are now in the process of adopting juries. The book delves pretty deeply into the reasons for the jury, of which there are many. It gets into some profound philosophical and political questions about the use of lay jurors in the justice system. But even though I've spent decades working on the jury, when you work on a book of this scope, there are always things that jump out at you that you hadn't realized the importance of before. And one of those is the speed of jury trial at the time of the founding of this country, in the late 18th century. Jury trials whizzed along. They really did. So in the Old Bailey in London, the Old Bailey is the main criminal court in London. And I strongly recommend that you go see it. They have visitor galleries. There are lines you can wait on, usually not too long, to get in. And I recommend that you go see it. Judicial tourism is always a good thing. In the 18th century, the Old Bailey in London, a single judge could get through between 12 and 20 jury trials a day, felony jury trials a day, with an average in the upper teens, which I never quite understood. I always thought there must have been a holdout somewhere, you know, that how could they possibly move that fast? And jury trials in this country were very fast as well. Well, writing this book brought home to me the importance of an old common law rule. From the time the jurors were sworn until the time they gave their verdict, the jurors were basically prisoners. They were not allowed to have, in the classic formulation, meat, drink, fire, or candle. So in other words, food, drink, heat, or light during that entire time. And the judges took this very seriously. There was one poor juror in the 15th century who tried to sneak a little apple into jury deliberations. And the 12 judges of England met to decide what would happen to this poor juror. Would he be fined? Would he be imprisoned? So they took this very seriously. Well, that kind of deprivation has a way of concentrating jurors' minds. It was also a restraint on counsel from going on too long. Jurors would get hungry and cranky. So this had a lot to do with the speed of jury trial at that time. If you read the book, you can also find out why some people preferred to be pressed to death rather than face jury trial. So pressing was being laid out on the ground with boards on your chest, this is for criminal defendants, and weights piled on the boards until the person either agreed to jury trial or was crushed to death. There's an illustration of that process on page 19 of the book. You can also find out why the jury trial was abolished in India. And the answer has to do with the Nanavati case in 1959. That was a case involving a multi-ethnic love triangle. The jury had to decide whether to convict the husband for shooting the lover. I will let you read the book to find out the juicy details and what the jury did in that case. And there's an illustration, a picture of the quite handsome couple on page 97. We need to remember, too, that juries have caused some very serious miscarriages of justice. And one of the first examples was the trial and conviction of Socrates in 399 BC in Athens. And in the United States, one of the most prominent examples is the acquittal of the murderers of Emmett Till in 1955. So jury nullification is not always something to be celebrated. A final thing that came home to me and that I'd like to leave you with is that juries around the world can take many different forms. And I should emphasize here that the civil jury has been abolished nearly everywhere. The US is the only jurisdiction that has, essentially, that has the civil jury. So when we talk about the jury taking different forms, we're talking about the criminal jury. One feature of the jury that can vary enormously is size. So ancient Athenian juries could have hundreds or even over 1,000 jurors. The largest Athenian juries were 1,500 jurors. And somebody I know was saying, imagine 1,500 angry men. But the idea was that the jury should represent the views of the people. And to do that, you need large numbers of jurors, and you need them randomly selected, which is what Athenians did. So some countries vary the size of the jury according to how important the case is. In South Korea, you could have a jury of 5, 7, or 9, depending on the type of case. Criminal juries elsewhere do not have to be unanimous. The jurors don't have to all agree. For example, England now uses 10-2 verdicts, and Jamaica uses 9-3. And this worldwide movement away from unanimity is interesting in light of the US Supreme Court's fairly recent decision in Ramos versus Louisiana in 2020, which held that criminal juries in the US have to be unanimous under the Sixth Amendment. The rest of the world is moving away from unanimity. So it's an interesting decision in that respect. Some provinces in Argentina are concerned about the composition of the jury along the lines of race and sex. And so they use quotas. Argentine juries, or some of them at least, have to be half men and half women. So a jury of 12 has to be 6 men, 6 women. In the case of an indigenous defendant, the juries have to be half indigenous, of the same tribe as the defendant, and half other sorts of people. One of the most interesting forms of the jury, I think, is what I talked about with respect to the French case, and that is the mixed panel. These are mixed groups of professional judges and lay jurors that all sit together, they deliberate together, and they vote together. This form of jury got going in the German state of Hanover in the 19th century, and from there it spread all over the world. Most recently in Japan in 2009, have adopted the mixed panel. Japan uses a panel of 3 professional judges and 6 lay jurors. And there's an illustration on page 30 of the book. And I'm especially proud of that illustration because it's an original artwork that I commissioned from a Japanese artist. Because the photos on the Japanese Ministry of Justice website were terrible. There's got to be a better way. In the US especially, rates of jury trial have been declining. Civil cases settle, criminal cases end in a plea bargain. In the US today, in federal court, of felony cases reaching disposition, 97.5% end in a guilty plea. So let me repeat that. Of felony cases ending in a conviction, 97%, over 97% are the result of a guilty plea. And that's despite the right to criminal jury trial being twice in the US Constitution, one in Article 3 and the other in the Sixth Amendment. So as Máximo has written, he's written extensively about abbreviated procedures elsewhere in the world, and all around the world these abbreviated procedures are increasing. But in other places, the so-called plea bargain is not a deal between the defense and the prosecution. It's mainly a deal between the judge and the defense, with the defense having full access to the investigative file. So it's a different thing than our plea bargaining in America. I think that lay participation is important, especially in criminal cases. It helps to legitimize the system. The people are more likely to accept decisions of the criminal justice system if ordinary people have a hand in making them. Well, that said, jury service can be hard on jurors. A criminal jury in Australia had to listen to 3 months of lengthy testimony from 105 witnesses. And the judge was complimenting the jury, noticing that many of them were staying alert and taking notes. One of the defendants noticed, while he was testifying, that the jurors were writing vertically. And it turned out that the jurors had organized a Sudoku tournament. So, thank you. I'm looking forward to Anna's and Maximo's comments.
Thank you so much. It is an honor to be here in such distinguished company and to have the opportunity to talk about this incredible book. So I can start by saying that now more than ever, we need historical and comparative scholarship that allows us and also encourages us to imagine radical and inclusive alternatives to the legal institutions like the jury that we feel we know so well. And this is precisely what Renée offers us with her new book on the jury. Here we have a work of remarkable erudition and comprehensive research that enhances our understanding of how lay decision makers participate in not only resolving disputes, adjudicating guilt in criminal cases, but also in reflecting on shared sensibilities about what justice can and should look like. Renée's writing, I encourage you to read the book. It's wonderful that you all have copies. It's incredibly engaging and accessible and weaves together strands of a complex institution and all of its comparative variations into a memorable and thought-provoking précis. So in the short time I just want to highlight 3 of Renée's core insights, each of which I think is worth discussing further. So first, we tend to think rather ethnocentrically, as American researchers, that more juries simply equals more democratic representation in our legal system. And of course, a jury is what its society makes of it. And as legal anthropologists like Larry Rosen and Carol Greenhouse have shown, we can't take for granted that the jury itself exists as a transhistorical or transcultural institution. Bodies of lay decision makers and the processes through which these bodies deliberate and enact judgment reflect distinct cultural practices and norms. Thus, all layperson juries are not necessarily, as Renée shows, more egalitarian in their operation than the mixed court or mixed tribunal counterparts that are discussed. As Renée writes, quote, lay jurors on mixed panels have shown that they sometimes do affect the outcomes of cases, particularly the sentences. We know, as Renée talks about in the book, and mixed tribunals, we have lay and professional judges deliberating side by side to render verdicts, often producing written, reasoned verdicts with a lay hand in determining sentences. In my own empirical research in Norway, I can say that the ethnographic research truly bears that out. Whereas as an American, I came in asking, why are you abolishing all layperson juries? The question I received in return is, well, in a socially equal society, how could we possibly imagine, that we'd have lay decision makers serving as a check on an overreaching judicial authority when alternatively we could have lay and professionals sitting and contributing to discussions and deliberations in equal measure. So the all layperson juries we may take for granted in the United States are also, as this book shows, not necessarily more representative in their constitution. On page 56, Renée talks about property qualifications for jurors in England before 1972. This excluded much of the working class, which she notes rented rather than owned their homes. Interestingly, right, a vestige of this classist, right, exclusionary thinking has also taken root even, right, in America, where it's very routine in federal court for prospective jurors, otherwise eligible to participate even today, to be asked, do you rent or own your home? This is, for example, on the New York Standard questionnaire. A fascinating point of comparison here that Renée discusses can be found in Japan and South Korea's integration of lay decision makers to very explicitly try to mitigate class bias on the part, she talks about, of judges. Another important insight here, Renée notes that the presence of juries is also no guarantor of frequent jury trials. And she looks here at the pervasiveness of guilty pleas in the United States, observing, quote from page 71, not bound by tradition or by inflexible constitutional rules, some civil law systems have succeeded in introducing lay participation into a greater share of cases than the United States has. And also importantly notes that all layperson juries, right, in this country are accompanied by additional legal constraints on their autonomy. Rightly, as I also teach evidence, Renée talks about the rules of evidence as the law of jury control, which they very much are. And of course, this is not the case elsewhere. Norway is just one example of a place that maintains a number of adversarial elements in its common law-based system while dispensing altogether with rules of evidence that take this sort of patronizing approach to how juries should receive evidence. Here Renée's discussion of evidence alongside sections on judicial comments on evidence, reasoned verdicts, the requirements that jurors answer specific questions, all invite us to think about how different approaches to jury control reflect the power of different constituents within legal systems, lawyers in the US, in civil law countries, anxious judges, as she describes them. Another core insight of the book is Renée's shedding light on problems of the American legal system's adversarial approach to voir dire, which produces juries, which she notes, that are neither impartial nor representative. An important point of contrast here is highlighted with the example of Argentine provinces that impanel men and women on juries in equal number. This was a practice adopted by Norway before it moved away from all layperson juries. The US would have great difficulty implementing this so-called quota system, even if people wanted it, due to a very common view here that caregiving by female jurors is typically legitimate grounds for cause excusal, or in some jurisdictions, de facto exemption. So without reforms targeting juror compensation, modification of trial schedules, even service provision by courthouses, the disproportionate excusal of women here in caretaking positions is likely to persist. Beyond this, the 10-minute jury selection proceedings that Renée notes in England on page 65 and conflict of interest excusals that predominate in Germany only further highlight the idiosyncrasy of this country, which, as Renée highlights, invites scrutiny of prospective jurors on a number of fascinating grounds, right? Religious beliefs, political affiliations, charitable contributions, where we consume our media, what we do with our free time, and so on. And there's one last dimension of Renée's book that I'd like to just touch on. In particular, it signals what I think are very promising and important avenues for reform, focusing on the integration of technology as an aid to more inclusive and expansive lay participation. For example, she emphasizes the importance of jury representativeness and contends that technology can expand jury pools. And this should be taken seriously by advocates of more inclusive jury systems. Renée discusses enhancing the representation of racial minorities, the self-employed, the very young, the very old. She also writes that technology may make it possible to rethink the presence of experts in jury trials. On 130, she notes that with no travel costs, experts could be assembled from anywhere in the country or world, though perhaps they wouldn't get paid for trips to Paris, right, which would be a real downside here. Another population that would benefit here, as my research has explored, are otherwise eligible prospective jurors with limited mobility, disabilities affecting their hearing, sight, or of course, non-delegable caretaking responsibilities and so on. So here I think pandemic era jury trials really can, as Renee notes in the conclusion of her book, offer promising lessons, right? Jurors, as we saw, can be provided with devices. Remote voir dire was implemented in some jurisdictions. So to conclude, all in all, the jury must be one of the most poorly understood legal institutions with which most Americans have at least some passing familiarity, if not personal experience. Renee's book is both a much needed primer and a map through history and across the world that does what I think the best anthropological scholarship does: open its reader up to a new understanding of a subject through exploring how it has been done before and elsewhere. I'll stop there. Thank you.
Should I go next?
It's your turn.
Yeah. Good afternoon to you. Good morning here in California, sunny California, as usual. It's a pleasure to be, and an honor to be here with all of you and to discuss this excellent book, The Jury, short introduction, and also in company of the distinguished panel, as it was mentioned earlier. The book is, I think it's fascinating, and it's an excellent book. It works within a very particular genre that basically it's a book that I think it's fair to say, and everything I'm going to say, it's a question also for the author, right? But it's a book that I think it's probably aimed at either a general audience or a general law audience. Meaning a general audience with some legal background, right? Or a general audience. And it's very hard to write these books. I've never tried to write one, in part because I find the whole task overwhelming. Why is that? Well, we academics are used to cite, to cite 1,000 words every time we write about anything, right? So, any law review article has to have over 300 footnotes. This book has no footnotes, right? So that's in itself, beautiful and refreshing. And still, it shows, right, all the existing literature and research behind the topic, right? So it kind of gets the best of both worlds, right? We do have the research there without having to go into the particular footnotes. The book is remarkable in its breadth, because it covers history, going back to ancient Greece, right, as Professor Lerner was saying, to today. It covers the world in a way, right, in the sense that it has a clear comparative lens. It covers also some of the main discussions about the regulation of the jury, right, in the US today, right, from jury selection to size, decision-making rules, and more. It also discusses both criticisms and defenses of the jury, and perhaps because the jury is in the Sixth Amendment, and of course also in Article 3, right, of the Constitution, never truly says, well, should we abolish it in the US, right? But, I guess, that's, again, it shows nuance there too. And I love the illustrations, I really do. And so they speak by themselves, and they are wonderful, right? Not only the one about the Japanese mixed court, right? But all of them. So congratulations to Professor Lerner for all of that. I'm going to simply make a few comments in the spirit of questions really to the author, right? And they will come in no particular order, even if I will try to, to give some analytical frame to each of them and to name each of them. The first question, I guess, it has to do with history, and specifically with the relationship with a topic that Professor Lettow Lerner talked about, right? Which is the possible relationship between trial by jury and plea bargaining. Professor Lerner talked, for instance, about the length of jury trials and about how jury trials in the Old Bailey were so short and many of them could be held on the same day. Of course, Professor Lerner's mentor, I believe, right? Professor Langbein has written about this extensively, and Langbein's thesis, right, that the book kind of seems to embrace, is the idea that there is a relationship between trial by juries in the U.S. And in England too, eventually, but in the U.S. becoming more adversarial, and lawyers coming into trials by jury, and plea bargaining. Why do I say that? Well, in the Old Bailey, yeah, many trials by jury could be held in one day, right? But in part that was the case because about 4% of the cases, right, had any sort of lawyer, right? And until the 1830s, right, lawyers were at least not formally allowed to do, to argue about anything but points of law, right, according to English law. So is this an ideal that we miss, a trial by jury, right, about serious felony cases without lawyers? I guess not, but I don't know. Again, everything I'm saying, right, it's posed as a question, right, even when I mention it as a comment. Is also, historically speaking, right, there are other hypotheses and other theses that have been defended by historiography, right, about why plea bargaining arose in the U.S., right, in the 19th century, or at least it became a widespread practice in the 19th century, that had nothing to do with the length of the trials, right, and nothing to do with adversarialism, right, at least in the sense that Professor Langbein emphasizes. So, for instance, there are some stories or historiography that emphasizes professionalism, right? As the prosecutor function become more professionalized, right? Prosecutors look for ways to handle their cases, right? Different from trials. There is, of course, a hypothesis about caseloads, right? Including, for instance, civil caseloads, right? Thinking about George Fisher's book. There are also hypotheses about kind of law and society, right? And broader political and cultural factors explaining the rise of plea bargaining. And so I guess my question there would be, in a book that is so rich and it has so much, right? The book seems to adopt that hypothesis, Langbein hypothesis, and I wanted to, again, ask, why if you think that that's really the main hypothesis to explain the rise of plea bargaining. In relation to that, the books, for instance, talk about Duncan v. Louisiana, right, and kind of the constitutionalization of the right to trial by jury, meaning by that the imposition to the states, right, of the Sixth Amendment, right, through the incorporation doctrine. Well, do you think that if today trial by juries were shorter, is it really likely that plea bargaining is going to be a practice less widely, right? Another question in that space. How do we account for the fact that today we have plea bargaining or other abbreviated mechanisms, as Professor Lettow Lerner preferred to call them, and all over the world, right? And still, right, we don't have the American trial by jury all over the place. So a number of questions about that, again, to spark a conversation in that regard. Second set of comments, or third, if you want, have to do with trial by jury in the civil law world. The trial by jury is spread all over the world. Well, of course, first with English colonization, right, in different forms, then with the French Revolution, right, and Napoleon criminal procedure code and, other things happening in the 19th century. But there has been really a recent spread of trial by jury, different versions of trial by jury around the world, right? And Japan was mentioned, Argentina was mentioned, right? And we could bring up other examples. I have to say, as a comparativist who love comparative law, who believe so much in the importance of comparative law and the like, that generally speaking, this is not an area where, when I see, for instance, the German mixed courts, they are fine, right? But they really don't evoke any of the historical, crucial importance that trial by juries had in this country, right? Yes, for sure, there are all sorts of biases that jurors have. There are all sorts of problems, right, that the work of Professor Offit and others, right, may show, right, about trial by juries, etc., right? But the role that the trial by jury played in the history of this country, right, in terms of kind of independence, right, from authorities, impartiality, right, at the time in which, the whole England was run by 12 judges, or in terms of kind of, siding with the little guy, right, when we live in societies in which legal systems tend to be tilted one way or another structurally, right, against him, her, them, right, is again something that I do not take lightly, right? And looking at examples around the world, I don't see anything equivalent to that, right, outside of the Anglo-American world, right? So I wonder, what do you think, that the U.S. could really learn from here? And of course, there are all sort of things to learn, right, and to talk about, right, but what is there anything to admire out there, right? That would be a way to pose, right, this question, right? And finally, because my time is running out, let me ask a final set of questions, which is about the future, right? About the future. If a professor Offit talk about technology, right? It's discussed at the very end of the book, right? In the conclusion, right? But it occupies most of the conclusion of the book at the end. And I was also fascinated by it, right? And I would like to hear more about this, if you could develop more, right? What do you think about, that how this can contribute to, the jury of the future, if you want? Is there a distinction to make between civil cases and criminal cases in this regard? What type of considerations we should take into account? And more generally, I mean, at the end, you do mention, also maybe striking peremptory challenges, right? And you also, again, talk about mixed courts, which I already expressed my skepticism on. But what else you think, right, that the jury of the future needs, right, either in the United States or elsewhere? So thank you very much, and I'm looking forward to continuing the conversation.
Oh, thank you very much to both of our commentators. And so Professor Lerner now has about 5 minutes, if you can,
All right,
to answer any one or many of those comments, and then we'll open it up to the rest of the
all right.
audience.
Well, it was very rich. There's a lot there. So thank you to Anna and to Maximo. One thing that they both mentioned was the possibility of technology changing jury trial. And I'm fascinated by that. And as I say, it comes mainly in the conclusion of the book, where I sort of thought through, did some thought experiments about what could it be like. And remember, those Athenian juries that were hundreds or even over 1,000 people. Well, you could get very large juries if you use technology, right? If you have remote jury trials, you could have very large juries, and they could be more representative, as Anna mentioned in her comments. You could get people who might have difficulty coming into a courthouse who could participate in jury trials, as long as they were concise, right? So another big point. So that could certainly happen. They could be more representative. The other thing that could happen with remote juries is the possibility of special juries. These were actually pretty common in the late 18th century in England, and they came to this country as well. So these were juries in particular types of cases. So for example, a complicated commercial transaction case, which did exist in England in the late 18th century, Lord Mansfield said, you know what, I'm not wildly competent at this kind of decision, and I'm going to get a jury of merchants, and they're going to tell me. And likewise with marine insurance cases, very important type of case in late 18th century England, he said, you know, I don't know whether this captain did the right thing in this particular storm or what have you, but I'm going to get a jury of sea captains, and they're going to help me. So that's what he did. And I think we could do something similar, especially for very complex civil cases, of which there are a lot, and IP cases famously. I mean, it really doesn't make much sense to put a patent infringement case in front of an ordinary jury. And it really doesn't make much sense to put it in front of most judges either, because these are very complicated. The lawyers barely understand the technology. And you would be better off, I think, having these kind of panels of experts who could help out the judge, and in effect, special juries. And that would certainly be well within the Seventh Amendment. That was an established practice in the late 18th century, and in England and in this country as well. So I think those are some advantages that technology could have. Already we see trial lawyers that are really taking to remote voir dire. You know, they are at least the initial phases of jury selection, and with a little judicial nudging, they could also be persuaded to do just full-scale voir dire, if we maintain that system, remotely. And you find that jurors give a lot more candid responses when they're in their own homes. And furthermore, the lawyers and the judge and so forth can see what the jurors are doing. So, you know, they may be grooming a pet, or they may be on an exercise bicycle, or lying in bed, or what have you. But it gives more information about the jurors if that's what we want. So I think there are a lot of different possibilities for use of technology with respect to jury trials that could really revivify it. As for the phenomenon that Máximo points out of abbreviated procedures all over the world, right? We know how dominant plea bargaining is in the US criminal justice system today. Other countries are also turning increasingly to abbreviated procedures. As I described, they're a little bit different. They're not so much a deal between the prosecution and defense, but between the judge and the defense with full access to the file. And that phenomenon, I think, now Máximo, of course, I'm sure, and probably Anna too, has some views about why this is happening. But let me take a bit of a stab at it. I think that other countries are being somewhat infected by our adversarial system. I think the lawyers, particularly defense lawyers, are becoming more aggressive than they have been in the past. And I've heard that from Germans especially, that now the German defense lawyers are more aggressive than they were before, less deferential to the judge. And related to that, the numbers of white-collar cases is going up. So these are complicated cases with defendants who tend to be wealthier and therefore can afford more expensive, aggressive lawyers. And so I think those two phenomena kind of feed off each other in making the normal criminal procedure in all of these places more and more unworkable. And so people are turning increasingly to some sort of abbreviated procedure. Just a quick note on my favorite abbreviated procedure, which comes from the Italians. The Italians are geniuses at coming up with ways around formal law. And one thing they've done, this came from the Italian judges. So Italy decided it was going to go full-bore adversarial with the judge not having the investigative file. Now, folks, I mean, the key to a civil law system is the judge having the investigative file. because the judge has to be able to have that to ask the questions of the witnesses and the defendant. And if the judge doesn't have that, it's not a civil law judge. So the Italians were like, okay, well, the Italian government says we're going to take it away from the judges. But what the Italian judges did is tell defendants, you know what? If you let us decide this case on the investigative file alone, without any oral proceeding, except possibly hearing from the defendant, but basically on the investigative file alone, we will give you, defendant, a 1/3 discount off your sentence if we convict. And I call this trial on the file. And a lot of defendants thought this was a great idea. And that's called, and Francesca, you have to forgive my accent, it's called giudizio abbreviato. How did I do?
Excellent.
Oh, okay. Well, anyway, or abbreviated judgment is what they call it. But the thing is about that, it gives you some adjudication, unlike our plea bargaining system, which has none, right? It's just a deal between the prosecution and the defense. A lot of the time, the defense doesn't even have the file, doesn't even have the information that the prosecution has, and so they're kind of doing it blind. But at least with this trial on the file, there's some form of adjudication.
Thank you. Thank you very much for all those incredible insights. And now we have 10 minutes, so we'll open it up to the audience. First, Professor Pierce, and then we'll move to...
I don't know if you're aware of this, Renee, but this term, the Supreme Court is deciding a case called SEC versus Jarchese, in which the Fifth Circuit held that the Securities and Exchange Commission does not have the power to adjudicate securities fraud cases because the Seventh Amendment compels a jury trial in all such cases. And some of the amicus briefs have come in urging a broader holding that agencies have no power to adjudicate any cases. They all have to go to jury under the Seventh Amendment. I wonder what your thought was on that dispute that the Supreme Court is going to be deciding this term.
Yeah, so going to the public rights doctrine, basically, on what can be decided by agencies and non-Article III judges. It's kind of what it comes down to, right?
Yes, but the Fifth Circuit has version of the public rights doctrine differs dramatically from the version that, at least up until the court's decision in this case, has been true in the Supreme Court.
Yeah.
They hardly have anything in their public rights box.
Yeah. Well, what I'd say about that is the Seventh Amendment certainly does not require jury trials in all civil cases. And in particular, anything complicated did not go to an ordinary jury in the late 18th century. So you would be well within an originalist understanding of the Seventh Amendment to say, no, certain types of cases do not go to juries. Now, whether they have to go to an Article III court may be another question, but they would not have to go to a civil jury trial. In fact, English judges, as I mentioned, if they saw a complicated case, either they would send it to equity, that is the chancellor, who did not use juries, or they would decide it themselves, but with a special jury. So with a jury of merchants or sea captains or whatever you have. So that was the case at common law. So if you want to take an originalist view, they wouldn't have sent a complicated case to an ordinary jury.
Thank you. Yes, you in the front.
So if we do move to a more remote jury system, like even during the trial, how do you think that would affect kind of the integrity of the verdict, like with the potential jurors not paying attention or playing games on their computer, or even like somebody impersonating another juror for their Zoom account? Like, how do you think that would affect the verdicts?
Yeah. These are difficulties already in remote jury selection where it's been done. And so basically you can use similar tactics to essentially proctoring online exams and these kinds of things. You can require the camera to be on the person, various ways of verifying that it's really the person, and you could even do facial recognition technology and things like this to make sure. But it is, as we all know, it's a problem, right? If you're on a remote meeting and your camera doesn't have to be on, it's very tempting to just wander around and do all kinds of other things rather than focus on the meeting. So there would have to be some pretty extensive proctoring, I would think, of these online sorts of things. And the more successful jurisdictions that have used remote jury selection have done that.
I was wondering if you could elaborate on Mr. Langer's last point regarding if there are any lessons that the US system could learn from the different implementation of a jury system across the world or historically that you've conducted in your research.
That the US can learn. Oh, many. I mean, this is why I got interested in comparative law, right? Because if our system worked perfectly, I would say, all right, well, hands off, right? We should be proselytizing around the world. But our system really does not work all that well. And so I think we have a lot to learn from other systems. Yeah.
But what stands out to you, especially?
In particular, you'll notice that the civil jury has been abolished almost everywhere. When I talk to federal, especially trial judges, federal district court judges, in public they will always say juries are fabulous, because of some interest that they have. but in private, they will admit that they could easily decide civil cases. Criminal, though, they think should go to juries. So they draw that distinction. So I do think, now of course, we have this issue with the Seventh Amendment, and I don't think that's going to be repealed anytime soon. But as I was talking with Professor Pierce, complicated cases just did not go to ordinary juries. So that takes off the table potentially a very large number of civil cases today. So that's one aspect I think we can learn. Another one is the idea of the mixed panel, which I think is terrific, having the mixed panel of professional judges and lay jurors. I think that has a lot of advantages. It gives you lay participation in the case, which I think is important for legitimation. But it helps to keep the lay jurors focused on what's important in the case, because sometimes lay jurors will go off and they'll find things that aren't terribly central, and they'll focus on those in making their decisions. Or they'll follow a powerful leader on the jury. And so I think the mixed panel mitigates a lot of that, but does give that lay participation, which is important, I think, especially for sentencing purposes, because these mixed panels decide guilt and sentence at the same time. And very often the lay jurors do influence the sentence.
Well, excellent. Tanya's excellent. The presentation and the book are amazing. I think we've really run out of time. There's so many things we could discuss, but they're all in here. And then you can take it up in person with Professor Lerner after class or during class. So that all we have left to do is to thank our terrific speakers here on Zoom and thank our author, Professor Lerner. Thank you.